Thanks, guys. Good afternoon, everyone. It's really an honor to be here. And thank you, Professor Lampron, for that very kind introduction. And I also want to extend my gratitude to the organizers, CLIDAC and l'Observatoire and Geneviève Newton and Régie Corsat for their very kind invitation to join you today. And just from my own personal perspective, it feels so wonderful to be in what I feel like is a normal country. Everybody's been so polite and so nice, even though we've been a really bad neighbor recently. So thank you all for this opportunity. And I'm really happy to be here today because this is the culmination of actually a year of discussions that I've been having with Professor Lampron. He was in New York last year for a sabbatical, visiting scholarship period, and he came to Columbia for a couple of events, and we had a chance to talk, and we realized that there were quite a lot of synergies between l'Observatoire and CLIDAC, and then the work that we're doing at Global Freedom of Expression. And we started to kind of brainstorm on like, what could we do to cooperate more? And so I believe Professor Lampron has given you some basic background information on our center, but I'll do it now in English for you. And basically, our initiative was started back in 2014 by then Columbia University President Lee Bollinger, and he's a First Amendment scholar. And he was at Columbia for 20 years, and during his tenure, he really worked hard to position the university to work on global problems from a global perspective. And so for us, what that meant is that our initiative was set up really to strengthen global norms on freedom of expression, to build bridges across jurisdictions and disciplines. And even though we're based at an American university, we don't really look to the First Amendment as our primary foundation. We really look to Article 19 of the International Covenant on Civil and Political Rights. And so that international perspective anchors our work in comparative law, universal principles, rather than national jurisprudence. Our flagship project, which I think Professor Lampron explained to you, we started building this over 10 years ago. And right now on the English side, we have over 2,500 analyses of court decisions from over 130 countries. And we have smaller versions of the database available in Spanish, French, and Arabic. We add new case analyses every week, about 3 to 5 from a range of jurisdictions. And over the last decade, we've partnered with UNESCO. They've been really critical for us because they've allowed us to expand the database thematically and linguistically, and they supported the different language versions of the database. They use our database in their judges training programs in Latin America and Africa. Has anybody seen the database? Anybody worked with it? Okay, well, good. This is a total introduction to it. Well, I'll tell you a little bit more about some of the things that you can find on it. We developed a special collection paper series a number of years ago, and the idea behind it was to systematize the case law in the database. And so we wanted to make it all very accessible to our users. So we have a range of these papers. Some of them survey the case law from the regional courts. Then we have others that are more thematically focused. There are papers that deal with freedom of expression and privacy and the right to protest and internet shutdowns. And we've got about 13 to 14 papers right now. And we also have 7 that are translated into French. So I really encourage you to get on to our publication side and take a look at the database. We hope that it's a really great resource for scholars and practitioners. You launched the French version of the database last year, right around this time, and just fortuitously, right around when I met Professor Lampron. And when we were thinking about how we might cooperate, it seemed to make the most sense to start with the French database. And I'm very happy to announce that since September, we have Thomas here, and he's a legal researcher for us. From what I understand, is an alumni of this esteemed university, and he's now doing his master's degree at Laval. And right now he's working on translations from English into French, and we're doing about 5 translations each week. And then come January, we're going to start with case analyses of from French jurisdictions and have those put into the database in both languages. We're really trying to grow this database. But I think the bigger hope is that this cooperation will build a community of practice, and it's really going to hopefully build a bridge between the French and English-speaking scholars and practitioners who are working to defend global freedom of expression, or freedom of expression on the global level. Most importantly, I think also this cooperation comes at a very important moment in time. As we've all been witnessing over the last decade, we're seeing the rise of populism, the rise of authoritarianism, and this is compounded by the challenges of climate change and artificial intelligence. And as we've also all seen since January 20th of this year, these trends have accelerated. So these are formidable challenges, not only for democratic governance, but also, sadly, to humanity itself. So it's really not a time for silence. It is a time for international solidarity. And as you've also all seen in the news, the United States is undergoing an extraordinary stress test of its democracy. The separation of powers, which is the cornerstone of democratic governance, is under siege. The president has sought to extend executive power beyond constitutional limits. And our Congress, rather than protecting its own authority and trying to restrain the executive, has largely acquiesced. So right now we're looking at the judiciary, and that is really standing as the last bulwark protecting our constitutional order. It's like the little Dutch boy with the finger in the dike, hoping to hold back the flood. It's a tall order, but I'm going to hopefully show some of the positive decisions that we have seen this year. But just to give you a sense of the scope of what's been going on, there is an organization called Just Security, and they've been tracking all of the cases against Trump. So right now, there's about 451 legal challenges to the Trump administration's actions. More than 60 of those directly implicate First Amendment claims. And as Judge William G. Young of Massachusetts recently observed, we have never had a president like President Trump. He's the first in our history to espouse the concept of a unified presidency, that the president alone is the superior executive motive force for all federal employees. So what we're really witnessing through all this legal maneuvering is a deliberate effort to circumvent the rule of law through both formal and informal means. We've seen this flurry of crazy executive orders extending presidential reach far beyond its traditional scope. We've also started witnessing his deal-making. And what this is, he's been trying to change public policy by transactional arrangements with private actors. And all of these actions really are manifesting into a campaign of targeted retaliation against perceived critics. It's been taking place against individuals, against organizations, and the institutions of democratic life, such as universities, law firms, and the press. And these all play a really important role in sustaining a free society. The aim, unfortunately, has been very clear. It's to punish disfavored speech, and in doing so, create a culture of fear and self-censorship. So again, today I'm just going to take a survey of a few cases that have been decided in the last couple months, and they focus on international students, universities, law firms, and the media. But we got to set the scene of where did this really start. On his first day in office, President Trump issued executive order titled Restoring Freedom of Speech and Ending Federal Censorship. Its stated purpose was to reaffirm that the First Amendment enshrines the right of the American people to speak freely in the public sphere without government interference. Sounds pretty good so far. Next, key policy provisions include the federal government declaring that no officer, employee, or agent may engage in or facilitate conduct that abridges Americans' free speech rights. So again, this all sounds pretty fine so far, but then it starts to get a little Orwellian. The order further prohibits using taxpayer resources to facilitate or support the suppression or moderation of speech that it asserts is protected. Again, sounds okay, but if you start to think about what's happening in the United States right now, where we've got the deployment of National Guard troops at taxpayer expense to police protests. If So the other thing that this policy does is it instructs the Attorney General to review federal government actions over the last 4 years for activities that may have been inconsistent with the policy and to propose remedial actions. And so this is essentially saying that the Attorney General has the authority to look back over the past few years and determine where there may have been violations of freedom of expression that the government can now move forward in prosecuting. And this has really become sort of a gateway for Trump's acts of retribution. To show how this is playing out, the first trigger for many of these cases came a mere 9 days later, on January 29th, when President Trump signed another executive order called Additional Measures to Combat Anti-Semitism. And this order directed federal agencies to identify tools to curb anti-Semitism and investigate universities for alleged Title VI violations. Title VI is part of the it's a part of the Civil Rights Act, sorry. And it says that if an institution receives federal funds, it may not discriminate on the basis of race, color, or national origin. And this order was issued, of course, amid lots of campus protests after the October 7th Hamas attack, and then the subsequent protests relating to the Israeli war in Gaza. And it became the foundation for a sweeping campaign against dissent on U.S. campuses. So under the guise of combating anti-Semitism, the administration targeted international students, particularly those who were Muslim or had expressed solidarity with Palestinians. The arrests and deportation proceedings that followed were chilling in both method and intent. The first case is the matter of Mahmoud Khalil. I don't know if you guys saw this one on the news, but he's a Columbia University graduate, and he was very active in organizing the Palestinian protests. He had never been convicted of any crime. He had never been arrested before. But ICE agents came to his home, and they arrested him in front of his 8-month pregnant wife. He was in the United States legally. The officers refused to identify themselves or their agency, and they whisked him off to an immigration court in Louisiana. So when he got to his hearing, he found out that his arrest was justified based upon Homeland Security Secretary of State Marco Rubio. Rubio had constructed this memorandum to the immigration court, which invoked a rarely used statute that allowed the deportation of any non-citizen whose presence in the United States the Secretary of State considered could have a serious adverse foreign policy consequence. The statute says that even when the expressive conduct at issue is otherwise lawful, the statute requires a personal determination by the Secretary of State that this conduct comprises a compelling U.S. foreign policy interest. So Rubio's memo, in effect, explicitly linked Khalil's lawful protest activity to anti-Semitism and claiming that it undermined U.S. commitments abroad. This statute's what's been called an ideological exclusion doctrine. And this type of statute was used actually during the Cold War and during the McCarthy era against communists. And they actually revised it in the 1990s, but it's been resurrected and sort of reconfigured for this particular moment. So Khalil, who was arrested in New York, he was flown to Louisiana to appear before this immigration court. Now, these immigration courts are administrative bodies. They are not true courts. They cannot review constitutional claims. And the immigration court found that Rubio's assessment met the legal standard outlined in the statute, and that the immigration court itself had no jurisdiction to question the Secretary's foreign policy judgment. Khalil's lawyers, in parallel, challenged both his detention and the statute in a federal court, which does have the authority to hear constitutional claims. In June, the federal court issued an injunction blocking his deportation, finding the government had exceeded its authority and ignored constitutional safeguards. The immigration court has since continued to try to deport him. The government has sort of pivoted its strategy, and now it's saying that he had actually lied on his green card and it is before an appeals court. There were hearings last week on the matter, and I believe those hearings are ongoing this week. So this is still an active case, and we will have to see how the court rules. Another case I want to highlight is another Columbia University student, Madawi, and he was an outspoken critic of the Gaza war. He participated in campus protests and demonstration. He gave public statements in support of international law, a ceasefire, and a peaceful resolution. He repeatedly emphasized the importance of human rights and condemned violence on all sides. So Madawi's been a lawful permanent resident of the United States for a decade. He has a house in Vermont. He's going to school at Columbia. He's never had any problems really with the law. And he was actually arrested at his naturalization interview. So he was at the courthouse, he had passed his test to become an American, and he was literally getting ready to say the Pledge of Allegiance to the American flag when ICE agents stormed into the room. They were masked, they were wearing hoods, they had guns, and they did not necessarily tell him who they were or what they were doing. They handcuffed him, they separated him from his lawyers, they put him in an unmarked van, and they tried to ship him to Louisiana. Luckily, along the way, there were some delays and he missed his plane. So he ended up getting stuck in Vermont, which was a really good thing for him. He has a really strong community base of support. There were a lot of protests on his behalf in Vermont. And again, the justification was exactly the same. Secretary of State Marco Rubio determined that he was a personal foreign policy threat to the United States. His lawyers had filed this writ of habeas corpus, arguing the arrest was retaliatory and violated the First Amendment, as well as the Fifth Amendment for due process. So on April 30th, the court agreed. The court found that he posed absolutely no flight risk or public danger, and the court ordered his immediate release. And there's three really great quotes from the court up here. But what's important is the ruling emphasized that the threat to democratic institutions did not come from Madawi's speech, but from the government's overreach and disregard for constitutional limits. So some common tactics that you'll see, we've got this reliance on this ideological exclusion statute, which allows deporting people for perceived foreign policy threats. We're seeing forum shopping, which is this transferring of detainees to these immigration courts in Louisiana, which is known for government-friendly rulings. And then we have bypassing judicial review by using these immigration courts that really can't hear cases on the merits. So together, these two proceedings show us how U.S. law is separating the administrative question of deportation and removability from judicial review of constitutional rights and government conduct. So there is some good news. In March of 2025, the Knight First Amendment Institute at Columbia University and the American Association of University Professors challenged the Trump administration's policy of arresting, detaining, and deporting non-citizen students who participate in pro-Palestinian activism. The suit argued that this policy deters speech and deprives academic communities of non-citizen perspectives. Citing the case of Mahmoud Khalil, Madawi, and a range of other students who had befallen the same problems, the complaint described a broader climate of self-censorship among non-citizen scholars. It claimed the policy, referred to as ideological deportation, violated the First Amendment, was unconstitutionally vague, and breached the Administrative Procedures Act, which simply requires that the government agencies follow fair procedures. On September 30th, a U.S. District Court in Massachusetts handed down a truly landmark ruling in favor of the plaintiffs. And what you're seeing up here on the screen is actually the front page of the court decision, and you'll see some handwritten language there. So what happened is the court, while it was hearing the case, received an anonymous postcard from an American citizen or somebody, and the postcard said, "Trump has pardons in tanks. What do you have?" And the judge put his response typed down below, and the judge wrote to this anonymous person, "Dear Mr. or Mrs. Anonymous, alone I have nothing but my sense of duty. Together We, the people of the United States, you and me, have our magnificent Constitution. This is how that works out in a specific case. So the court held that the two cabinet secretaries, Kristi Noem and Marco Rubio, intentionally and in concert violated the First Amendment rights of non-citizen university faculty and students. The court found by clear and convincing evidence that the secretaries deliberately chilled the free speech rights of the plaintiffs by targeting non-citizens for detention, visa revocation, and deportation based on their pro-Palestinian and anti-Israel political speech. The court found these actions were part of a, quote, invidious plan to target a few for speaking out in order, quote, to terrorize others with similar views into silence. In its ruling, the court unequivocally affirmed that non-citizens in the United States have the very same free speech rights as citizens. And the court concluded that the secretaries misused their authority to suppress unwelcome political views, a practice the court called scandalous and unconstitutional. So again, I've got some really great quotes from the court up there for you to take a look at. And another really interesting aspect of this ruling, aside from it being 165 pages long, which is quite long, it's written in very plain English. It's incredibly easy to understand. And it seems to me that the court really wrote this decision for the American public to read. It was as much for the American public as it was for the parties to the case. And just a couple other points that I think are worth highlighting in this decision. The court underscored that criticism of the state of Israel is not anti-Semitism. It is actually protected political speech. The court also called out Homeland Security and ICE tactics, stating that they are geared to terrorize and silence Americans and non-citizens. The judge also pointed to the fact that the president is not allowed to use the law or the courts for retribution. And finally, the court noted that the judiciary is trying to stand up to the president for misusing his authority, and the judge called on U.S. citizens to do their part in defending their constitutional rights. So we're seeing here that these cases reveal an emerging model of repression, the weaponizing of immigration and national security powers to suppress political expression. They also expose, sadly, the weaknesses of established procedural safeguards, which are bending to executive overreach. So the next wave of attacks targeted universities themselves, the institutions of higher learning. And there was, following the same previous executive order, the administration created a task force to combat anti-Semitism. Its stated aim was to protect Jewish students, but its real effect was to infiltrate universities to implement the government's agenda. The task force began by investigating 10 universities, and it started with Columbia and Harvard. In both cases, the federal government threatened to suspend or terminate truly billions of dollars in research funding unless universities accepted a list of reforms. These reforms were not directly related to security or discrimination even, but they were really veiled ideological directives. They required changes in faculty hiring, curricula, student organizations, and governance structures, effectively imposing government control over significant aspects of academic life. Columbia ultimately negotiated and signed a resolution agreement. Harvard refused and went to court. So Columbia was the first university targeted under this new federal funding review. And unfortunately, it came at a really, really difficult time at Columbia. As you may have seen in the news, Columbia had a lot of difficulty with the protests, and the police were called in. We had had a wonderful new president. She was there at the university for a year. She did step down right around this time, and it was largely due to the pressures from the ongoing Gaza protests. And Columbia at this point was facing intense political pressure, heightened public scrutiny, and also financial concerns due to waves of lawsuits and funding issues. So after several weeks of negotiation, Columbia reached a resolution agreement with the government, which restored roughly $400 million in suspended grants, but it did so in exchange for institutional reforms and a very nice payment of $221 million. Columbia's leadership described the outcome as a pragmatic compromise to safeguard students and research funding, but the deal has really raised a lot of concerns about university autonomy. Acting President Claire Shipman emphasized that in signing the agreement, Columbia was not admitting to any wrongdoing or violating any laws. And she asserted that the university retained full authority over its academic and operational decisions, noting that the agreement does not give the United States authority to dictate faculty hiring, admissions, or the content of academic speech. As she put it, this is our North Star. Yet, despite those assurances, the agreement does come with a lot of strings attached. And some of those strings include reporting obligations to a federal task force that has broad access to university data on students and faculty. It also requires periodic government reviews of so-called bias incidents. It requires the appointment of new faculty in very specific departments to ensure viewpoint diversity, and a plan to reduce financial dependence on international student enrollment. And one of the really strange provisions that it includes is that when Columbia is deciding what kind of international students to bring in, it has to have them disclose what their intent and motivation is to come to the United States. So it's a little politically charged. Legal scholars have reacted sharply. Columbia University professor David Posen has described the deal as part of a new transactional administration, where executive agencies are using ad hoc bargaining rather than established legal proceedings in order to reshape institutions. And I put a quote up there from Posen because I think it really kind of says it all. It says, "These deals will not be the product of thorough investigations or judicial findings of misconduct by the schools in question. No established legal process was followed for the Columbia Agreement. No genuine legal dispute was resolved. The deal-making is the main regulatory event from start to finish." In his analysis, the Columbia Agreement, quote, "gives legal form to an extortion scheme, one that circumvents congressional funding processes, undermines the separation of powers, and endangers academic freedoms." Other commentators echo this view, and I put some quotes up, some from former president of Columbia University, Lee Bollinger, and some others. And they warn that such arrangements erode the stability of research funding and blur the line between compliance and political coercion. More broadly, this episode illustrates how the executive branch is using claims of anti-Semitism and opposition to diversity, equity, inclusion programs as a pretext for direct intervention in university governance, setting a model for future actions against other institutions. And I've got the quote up here from Jerry Nadler as well. And there's been a lot of people from the Jewish community and Jewish leaders that have actually spoken out and said, these policies that the government are undertaking really don't make us feel like we're safer, because these are exactly the types of tactics that were taking place in World War II. So Harvard luckily chose a different path. Harvard received letters somewhat similar to Columbia in early April, and that outlined a set of reforms and conditions required to maintain eligibility for federal funding. These conditions included reducing the authority of faculty members who were identified as promoting activism. It required restructuring the recruitment and admissions process for international students to exclude individuals perceived as hostile to American values. It mandated external audits across academic departments to assess viewpoint diversity, requiring the auditing of academic programs suspected of ideological capture. And it terminated all diversity, equity, and inclusion initiatives. And it also involved the revoking recognition of student organizations allegedly involved in anti-Semitic activity. So it's important to mention, like, these notices from the government didn't acknowledge any of the measures that Harvard had actually taken to deal with anti-Semitism on campus. It also did not mean that there was any official investigation into the alleged Title VI violations, as is required by law. So these letters were really just all threats and allegations. Harvard responded that the conditions exceeded lawful authority, violated academic freedom, and intruded on internal governance. The government, as usual, replied with escalation. Within hours of receiving Harvard's response, the task force froze over $2 billion in research grants and $60 million in contracts. And ironically, in this very transparent government, the freeze order explicitly stated that they were responding to Harvard's statement today as justification, which is like a clear link between protected speech and punishment by the government. No matter. Trump, of course, took to social media, posting all sorts of interesting claims, and he threatened to revoke Harvard's tax-exempt status, its accreditation, along with additional funding. Secretary of State, Homeland Security Kristi Noem further threatened to revoke Harvard's certification to host international students under the Student and Exchange Visitor Program unless the university complied with the extensive demands. So the situation continued to escalate until May 22nd, when the Department of Homeland Security effectively did terminate Harvard's ability to host international students. Harvard filed for a temporary restraining order, and the court responded within a day. So the court blocked the stopping of the student visas, and then in response, because Trump never takes no for an answer, he issued a presidential proclamation. And it was titled Enhancing National Security by Addressing Risks at Harvard University. The proclamation suspended certain categories of visas to any foreign national seeking to study at Harvard or participate in an exchange program at Harvard. The proclamation cited alleged increases in crime on Harvard's campus, the university's acceptance of funding from China and other foreign governments, as well as the enrollment of students from non-egalitarian countries as justification. An accompanying press release further characterized Harvard as having demonstrated a history of radicalism. This all resulted in two landmark rulings, and they're important because they really represent a crucial judicial intervention to safeguard university autonomy and academic freedom. So the first one, Harvard v. Health and Human, the HHS, the court held that the administration's freezing of over $2 billion in research grants violated the First Amendment and Title VI of the Civil Rights Act. The court found that the government's invocation of anti-Semitism was, in fact, a pretext for ideological control and retaliation against Harvard for rejecting its demands. The ruling emphasized that such actions infringed upon the constitutional protection of free expression and the independence of educational institutions. In the companion case, Harvard v. DHS, it addressed the suspension of visas for international students and scholars. The court found that the presidential proclamation barring foreign students from entry lacked any legitimate national security rationale and was instead an act of retaliation. The injunction restored Harvard's ability to host international students, and it reaffirmed the First Amendment's reach in protecting academic exchange. So both cases underscored the judiciary's recognition that universities play a vital role in democratic discourse, and that the government's interference in teaching, research, and admission policies strikes at the heart of academic freedom. Despite the strength of those rulings, Trump is undeterred. In early October, he issued what's been called the Compact for Academic Excellence in Higher Education, and it was sent out to 9 universities with a whole list of reforms that he was expecting. And they included the usual things. He wants colleges to cap international student enrollment, freeze tuition for 5 years, adhere to biological definitions of gender, and prohibit anything that would belittle conservative ideas. 8 of the 9 universities have publicly rejected this compact, and they've sent some feedback to the government on how they might be able to improve this. There is just this one last university, I believe it's University of Texas at Austin, that has not yet spoken out against it. So while these developments are really kind of shocking by American standards, they really are reminiscent of what everyone's been calling the authoritarian playbook. And these tactics have been used in places like Russia, Hungary, and even India. And I actually have a member of my team who's a Russian national. And she did her undergraduate work in St. Petersburg at a small college, and it's called Smolny. And it was eventually closed due to political pressure, but Smolny, when it first started, it was funded by George Soros's Open Society Institute, and it was started right after the fall of the Iron Curtain. And it established a partnership with Bard College based in upstate New York. Eventually, the college came under pressure in 2021, and this was at the time where Navalny had come back to Russia, and then the government arrested him, and protests erupted on Smolny's campus. So what happened at that point, a pro-Kremlin group filed a report to the Russian State Prosecutor's Office requesting an investigation into Smolny's ties to George Soros. Now, George Soros's organizations had all been outlawed in Russia at this point. And the group alleged that Soros and Bard were using Smolny to turn Russian youth into a protest electorate with a pro-Western and hostile ideology towards their own country. The St. Petersburg University cooperated with the prosecutors, who determined that Bard, in fact, did pose a threat to the foundations of the constitutional order and security of the Russian Federation, and designated the American College as an undesirable organization. So since June of 2021, Bard has effectively been banned, and Smolny more or less closed down. So this law on undesirable entities has been in constant use, apparently, against critics of the state, and any Russian citizen who cooperates with such an entity could face prosecutions. And if you've been watching the news in the United States, you've probably seen that the United States government has now named Antifa, this very sort of amorphous, really non-organization, to be a terrorist organization. So you can hear in the language the similar approach. And you're probably also aware of what's been going on in Hungary, where Viktor Orban's government used law and procedure to pressure Central European University. And that Central European University was also founded by George Soros and was supported by the Open Society Foundations. And it was ultimately forced to move its operations from Budapest to Vienna. So what Orban's government did is it also tried to exert control over the curriculum. It passed laws making it difficult or impossible for universities with foreign ties to operate. What was going on here did eventually make its way to the European Court of Justice, and they did rule that Hungary's conditions were unlawful under EU law and the EU Charter, but unfortunately this decision came too late as the university had already moved its operations. I was talking to a colleague of mine from India a couple weeks ago, and I was telling her about these cases, and she told me that there are similar sorts of things going on in India, where the Modi government is using government funding to change curriculum in Indian universities. So the third wave of litigation emerged as the administration moved on to target law firms. And again, between March and April, at least 5 executive orders or directives were issued against major law firms. And these orders did a range of things to try to cripple the law firms. They suspended security clearances, they terminated government contracts, and discouraged federal engagement with these firms. Some of these firms also did deals. They did preemptive agreements to try to keep the government at bay. 2, or actually I think there are 3 of the law firms did go to court, and they won swift and emphatic judicial victories. So I just want to highlight a couple of those. What's interesting about these 2 particular law firms is Trump clearly had personal animus against them. He had spoken out publicly about how he wanted to go after them, and he disparaged them. So the first one was against Perkins Coie, and Perkins is among the 50 largest law firms in the United States. It has more than 2,500 employees. It works with a broad range of clients, from individuals to non-governmental organizations and the government as well. It works on the state, federal, and international level. The executive order alleged that Perkins had weaponized the legal system against Trump and cited the firm's past election-related litigation and its diversity programs. So to give a little bit of context of how Perkins ended up in the crosshairs, in 2016, a subset of Perkins' lawyers represented Hillary Clinton during her 2016 presidential campaign. As part of their work, they hired a firm called Fusion GPS, and I don't know if any of you heard about this organization, but they were the ones that revealed the Steele dossier. Now, the Steele dossier it's highly controversial, but it alleged that it found evidence of collusion between Trump and Putin. So later in 2022, then former President Trump sued Perkins, alleging that they had conspired to fabricate a Russian collusion narrative. That suit was dismissed on September 8th, 2022, for having no merit, and the court subsequently imposed sanctions exceeding $900,000 against Trump and his lawyers for filing what the court said was a baseless case in order to dishonestly advance a political narrative. Skip ahead to 2024, Trump on his campaign trail continues to decry the widespread election fraud from before. He's vowing to prosecute anyone from attorneys to election officials who have engaged in any sort of misconduct. The executive order against Perkins suspended all of the security clearances, it compelled client disclosure, and directed government agencies to terminate contracts and deny any future work with the firm. And this obviously had an immediate and detrimental effect on the firm. Perkins filed suit on March 11th. Within one day, the court issued a temporary restraining order, followed by a final judgment and a permanent injunction, forbidding the enforcement of Trump's executive order. And the slide again features some key quotes from the decision. The DC District Court held that the executive order was unconstitutional retaliation and viewpoint discrimination against a private law firm for representing political opponents and engaging in protected speech. The court emphasized that the president's use of executive authority to punish legal representation strikes at the heart of rule of law. So then we move on to Jenner. We have a very similar situation with Jenner. The order denounced the firm's pro bono advocacy, including representation of asylum seekers and transgender individuals, other people who are targeted currently, and it also mentioned the rehiring of Andrew Weissman as part of the justification. Now, Andrew Weissman is a former federal prosecutor who served on the Mueller investigation into Russian interference in the 2016 election, so it's a clear pattern. The order also suspended the firm's security clearances, barred Jenner lawyers from federal buildings, and pressured federal agencies and contracts to cut ties with the firm. Now, Jenner did 40% of its business with the US government, so this was significant. The district court, again, same sort of pattern, immediately issued a restraining order and then a permanent injunction, finding that the order violated the First Amendment protections against retaliation and viewpoint discrimination, also infringed the Fifth and Sixth Amendment rights to due process and legal counsel. The court wrote, "This executive order seeks to chill legal representation the administration doesn't like, thereby insulating the executive branch from judicial checks fundamental to the separation of powers." So this brings us to the final piece of his most recent campaign, and this is, of course, involving the media, the essential link between government, courts, and the public. And just as the administration targeted students, universities, and lawyers, it turned its attention to journalists and the news. And, these efforts were a common thread: the use of state power, whether through investigations or funding control or access restrictions, to punish speech the government disfavors. So we're just going to take a quick look at three of these cases. The first case is widely publicized, and you probably read about it, and it's kind of a funny one. And it stems from executive order titled Restoring Names That Honor American Greatness, which included, of course, the renaming of the Gulf of Mexico into the Gulf of America. Now, the Associated Press has a style book, and they explained that they couldn't possibly revise that. It's international standard. And so they deferred to the president. They said, listen, we will recognize the name change, but we're not going to change our style book. And I'm sorry, we have to keep our standards. Immediately, they were barred from the White House press pool, which they had belonged to and been part of for decades. So the AP argued that this clear linkage between its style book decision and its exclusion from the press pool demonstrated yet again retaliatory intent beyond any legitimate regulatory purpose, in clear violation of their constitutionally protected speech. The AP also detailed how the exclusion significantly impacted its ability to perform its journalistic duties. It wasn't able to do the photography that it usually does. It couldn't report on the news in a timely fashion. And the AP submitted that it would suffer irreparable harm without injunctive relief due to the ongoing violation of its First Amendment rights and the professional and economic consequences stemming from its inclusion. So the AP sued, and the court ruled largely in its favor. The judge held that while the government can regulate access for logistical reasons, it cannot exclude reporters based on viewpoint. In weighing the equities, it emphasized that policy goals may never triumph over the Constitution. It further rejected the government's claim that the AP sought extra special access, clarifying instead that the AP sought only equal treatment alongside similarly situated news organizations. The court concluded that AP's exclusion inflicted concrete, irreparable harms on its ability to gather and disseminate news in real time. The court held the government unlawfully discriminated against the AP's viewpoint and retaliated against its protected editorial choices by excluding it from the press pool. So even though this ruling restored AP's access immediately and reaffirmed a very important principle that has guided American democracy for over a century, that a free press is not a privilege granted by the government. It is actually a constitutional guarantee. Unfortunately, the appellate court did not agree. The appellate court was a bench of 3 judges, 2 of which had been appointed by Trump. They felt that AP really could not succeed on the merits. So they overturned the first instance decision. It is now on appeal again. The AP is asking the full bench of the circuit court to hear its claims. So this is ongoing. We really don't know how it's going to turn out. But the sad story is it's kind of too late at this point. Trump has just marched on and completely reorganized how the press pool is organized and managed. So that battle may be lost until there's more significant change politically. The second case, another sad case, is RFERL v. Kari Lake, which concerns the U.S. Agency for Global Media, the body that funds Radio Free Liberty and Radio Free Europe. So this executive order was titled Continuing the Reduction of Federal Bureaucracy. And with that, the agency abruptly withheld congressionally approved funds and sought to impose new conditions on RFERL's editorial independence. RFERL went to court and was really just asking for a month's extension and $12 million so that it could continue to operate while this case was ongoing. It said that, given that it gets all of its financial resources from congressional appropriations, without these funds, it risks halting its mission of providing independent journalism across 23 countries. And it said that it would hinder the flow of reliable information to audiences abroad and compromise a mission that has been recognized by Congress as serving the interests of the United States for decades. It further argued that the executive branch was violating the separation of powers by overriding appropriations law and congressionally authorized funding. So the court did agree to a temporary restraining order, and it did compel the agency to release the funds. And at the end of the day, the U.S. agency allowed the funding to continue through September of this year. But what this means is we're now in a new fiscal year, and they have to renegotiate their grant. And unless its budget and legal protections and its institutional mission are secured in the long term, we really risk a major operational change, and we just don't know if they're going to be able to continue. But I guess what's really important about this case is that the court tried to recognize the need to protect editorial independence from political interference, especially to ensure that any sort of US-funded international broadcasters don't become propaganda arms of the state. And importantly, it also again tried to reaffirm the ability of Congress to allocate funds and protect the separation of powers. So the last case I wanted to tell you about is Media Matters v. Federal Trade Commission that was decided just a couple months ago. And this case actually began in 2022. And it happened after Elon Musk purchased Twitter. And he rebranded it into X. And at that time, as you all may remember, he changed a lot of the content moderation policies. And so Media Matters was kind of monitoring what was going on the platform, and it recognized that there was like an enormous amount of hate speech and extremist speech that started to emerge on the platform after these changes. So it kept monitoring things, and then a year later, Media Matters published a report, and it documented what it found, and it was seeing that advertisements of like major US firms, very reputable firms, they were showing up next to like neo-Nazi content and extremist content. So they published this report. And the advertisers, when they read this report, were quite alarmed, and they started pulling their advertisements from X. This, of course, made Elon Musk very, very angry. And he threatened to launch a thermonuclear lawsuit. And so what this led to was X launching a multi-jurisdictional legal campaign against Media Matters and the writer of the report. And this went on for a couple of years, but the retaliation escalated after Donald Trump's election. So he appointed a gentleman to the Federal Trade Commission by the name of Andrew Ferguson. And Mr. Ferguson was also found to be saying publicly that he wanted to go after progressive institutions. Shortly thereafter, he issued a sweeping subpoena, and it's called a civil investigative demand. And that forced Media Matters to hand over all sorts of internal records and communications. Media Matters sued, alleging that the FTC's investigation formed part of a coordinated campaign of governmental and corporate retaliation intended to punish and silence its critical reporting. The U.S. District Court granted Media Matters a preliminary injunction against the Federal Trade Commission, finding that the agency's broad investigative demand was likely retaliatory and in violation of the First Amendment. The court held that Media Matters reporting on extremist content on X was effectively quintessential First Amendment activity. The judge noted that the scope and invasiveness of FTC's inquiry really did appear designed to chill further reporting. The judge concluded that such tactics should alarm all Americans. But what's important about this is the decision really did try to reaffirm that investigatory powers cannot be weaponized to intimidate journalists or advocacy groups. So if we step back, the pattern is clear. We've got retaliation disguised as regulation, using official powers to punish critical reporting, the instrumentalization of administrative processes, turning agencies like the Federal Trade Commission into tools of political control. And then we have the suppression through access and funding. Whether it's the freezing of grants or cutting off of contracts or banning reporters, the aim is the same, to silence dissenting voices. And the courts have really tried to respond with clarity that the government cannot retaliate against journalists, regulate newsrooms, or deny access based on viewpoint. So again, stepping back, taking all of these cases together, these rulings reveal a remarkable through line. The courts have become the last functioning check on the American separation of powers. When every other institution seems to be bending to political pressure, It is the judiciary so far, at least the federal judiciary, that's been drawing the line, invoking the First Amendment, due process, and the rule of law as limits on executive power. As one judge wrote in the Jenner decision, retaliation against one firm threatens retaliation against all. It casts a chilling effect over the whole profession. And really the same applies to universities, journalists, and every citizen engaged in public debate. So these decisions, while they provide some hope, it's also really clear that the courts alone really are not going to be strong enough to do this on their own. And if you think about what happened in Brazil, it's sort of an interesting juxtaposition. The courts in Brazil had some similar problems to deal with, and they've been, I would say, more activist and much more defensive of their democracy. They ended up convicting Bolsonaro, finding that he did orchestrate a coup in order to undermine their democracy. Sadly, in America, we made other choices, and we let the January 6th, we gave the January 6th people pardons. So what can these cases teach us? They do reaffirm democratic principles and norms that we, as a citizenry, need to reclaim and champion. They remind us that freedom of expression is not a privilege bestowed by governments. It is the foundation upon which the legitimate government authority rests. The courage of institutions that resist coercion and deals, and the courts that defend them, reminds us that democracy endures not by accident, but through vigilance, solidarity, and the rule of law. So thank you for your attention.